Hello, and welcome to the HR Learning Podcast. My name is Heidi McCumber, and I'm sharing with you the things I love, anything having to do with employment law and human resources. As I read, you read. Today's post is about an EEOC news bulletin dated 2/13/20, where joint employers Select Staffing and Albuquerque Police Department allegedly failed to stop or prevent sexual harassment by the Albuquerque Police Department. Select Staffing agreed to pay $199,500 to settle the suit with the EEOC. The 2.5-year consent decree requires Select Staffing to review and revise policies prohibiting sex discrimination, sex harassment, and retaliation, and to provide training to all its employees in New Mexico. Select Staffing will report all complaints of discrimination and retaliation to the EEOC during the decree's term. Sexual harassment is a violation of Title VII of the Civil Rights Act of 1964. Note that in addition to the $199,500 fine charged by the EEOC, 4 women also filed their own sex and race discrimination lawsuit against APD-IPRA and the City of Albuquerque, which the City of Albuquerque resolved in a $490,000 settlement. The following is a word-for-word reading of the February 13, 2020 news bulletin. Select Staffing to pay $199,500 to settle EEOC sexual harassment suit. The staffing agency allowed sexual abuse of several women placed in jobs at Albuquerque Police Unit, federal agency charged. Albuquerque, New Mexico. Real-Time Staffing Services, Inc., Employment Solutions Management, Inc., and EmployBridge, LLC, all doing business under the brand name Select Staffing in Albuquerque, will pay $199,500 and furnish other relief to settle a sexual harassment lawsuit filed by the U.S. Equal Employment Opportunity Commission, the EEOC, the federal agency announced today. The EEOC charged that these entities failed to remedy or prevent sexual harassment of female employees who were placed in jobs with the Inspection of Public Records Act unit of the Albuquerque Police Department, the APD-IPR. According to the EEOC's lawsuit, women employed jointly by APD-IPRA and Select Staffing were forced to endure pervasive and unwelcome conduct based on sex. The EEOC charged that the women were subjected to sexual comments about their bodies and were referred to as prostitutes and dumb broads. The EEOC also alleged that some women were subjected to unwelcome touching and that men threw objects at them to demean them. The EEOC also said that the women reported the treatment to both the City of Albuquerque and Select Staffing, but that Select Staffing failed to remedy or prevent sexual harassment. Such alleged conduct violates Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based on sex, including sexual harassment. Senior Judge James A. Parker of the U.S. District Court for New Mexico entered an order on February 12, 2020, approving the consent decree settling the suit, styled EEOC versus Real-Time Staffing Services, LLC, FKA Real-Time Staffing Services, Inc., and Employment Solutions Management, Inc., and EmployBridge, LLC, FKA New Kusharam Corporation, DBA Select Staffing, Civil Action Number 1:18-CV-0541-JAP-JFR in U.S. District Court for the District of New Mexico. The 4 original complainants, Roberta Archuleta, Tiffany Dix, Barbara Houston, and Cristela Sanchez, joined in the EEOC's lawsuit against Select Staffing and also filed their own lawsuit against APD-IPRA and the City of Albuquerque. In May 2019, after investigations by the EEOC and the U.S. Department of Justice, the City of Albuquerque resolved the claims of sex and race discrimination and retaliation asserted against it in a $490,000 settlement. Under the terms of the 2.5-year decree resolving the EEOC's lawsuit against Select Staffing, Archuleta, Dix, Houston, and Sanchez, along with Cristina Chavez, another aggrieved individual identified by the EEOC, will each receive a portion of the $199,500 settlement. In addition to the monetary compensation, the decree enjoins Select Staffing in the future from engaging in employment practices that discriminate based on sex or that retaliate against persons because of their opposition to practices made unlawful by Title VII. The decree also requires Select Staffing to review and revise policies prohibiting sex discrimination, sex harassment, and retaliation, and to provide training to all employees in New Mexico. Select staffing will also report to the EEOC on any complaints of discrimination and retaliation received by select staffing during the decree's term. Both employers are responsible for preventing and remedying sexual harassment of employees, said Regional Attorney Mary J. O'Neill of the EEOC's Phoenix District Office, which has jurisdiction over Arizona, Colorado, Wyoming, New Mexico, and Utah. When employers fail to protect victims of sexual harassment, employers will be held responsible. We hope that this case acts as a teaching moment for other employers in New Mexico. EEOC's District Director Elizabeth Cadle added, "We appreciate this employer's effort to work with the EEOC to develop settlement terms that will provide improvements in policies and procedures. The actions of these women who bravely stepped forward to share the abuse they experienced will lead to safer workplaces for others. Preventing systemic workplace harassment remains at the top of our 6 national priorities identified by the EEOC's Strategic Enforcement Plan. The EEOC advances opportunity in the workplace by enforcing federal laws prohibiting employment discrimination. More information is available at www.eeoc.gov. Thanks again for listening to the HR Learning Podcast. Copyright HeidiMcCumber.com. All rights reserved.